The Texas Heartbeat Act is an act of the Texas legislature. It was introduced as Senate Bill 8 and House Bill 1515 on March 11, 2021, was signed into law by Governor Greg Abbott on May 19, 2021. The law came into effect on September 1, 2021. It is the first 6-week abortion ban in the United States, and the first of its kind to rely on enforcement by private individuals through civil lawsuits, rather than by the state through criminal or civil enforcement. The Act establishes a system in which members of the public can sue anyone who performs or facilitates an illegal abortion for a minimum of $10,000 in statutory damages. The Act has been characterized as a de facto ban on most abortion in Texas, and was challenged by the United States Justice Department 8 days after it went into effect on the grounds that it is preempted by federal law under the Supremacy Clause of the U.S. Constitution, and interferes with the performance of abortion-related services by federal government agencies and their contractors. The Act is also being challenged in state court. A different fetal heartbeat bill, HB 1500, was previously introduced in Texas by Phil King on July 18, 2013, in the wake of Rick Perry signing Texas Senate Bill 5 into law. The bill was not passed. The bill was joint-authored by Representatives Phil King, Dan Flynn, Dan Parker, and Rick Miller. As of February 26, 2019, HB 1500 had 57 sponsors or co-sponsors of the 150 members of the Texas House of Representatives. Former State Senator Wendy Davis said HB 1500 was the most dangerous I've ever seen. On March 11, 2021, the Texas Heartbeat Bill was introduced to the Texas House of Representatives by Representative Shelby Slauson, and to the Texas Senate by Senator Brian Hughes. The bill was considered a legislative priority for Republican lawmakers, and was included on Lieutenant Governor Dan Patrick's list of top priorities for the 2021 legislative session. Governor Greg Abbott signed the bill into law on May 19, 2021. The novel legal invention of the bill, private civil enforcement, was engineered by Jonathan F. Mitchell, a former Stanford law professor, former clerk for Justice Antonin Scalia, Solicitor General under Rick Perry and member of the Federalist Society. He proposed the idea in an 2018 Virginia Law Review article, The Writ of Erasure Fallacy, then brought it to the attention to an East Texas anti-abortion pastor in 2019 as part of his private practice. Another related act, the Human Life Protection Act, was passed simultaneously. The bill immediately bans all abortions in Texas, without exemption. If the Roe v. Wade precedent is overturned by the Supreme Court, the Act allows any person to sue someone who performs an abortion once a signal of cardiac activity in an embryo can be detected via transvaginal ultrasound, which is usually possible beginning at around 6 weeks of pregnancy. Though patients may not be sued, anybody who provides support can be sued in addition to physicians performing the procedure, including staff members at clinics, counselors, lawyers, financiers, and those who provide transportation to an abortion clinic, including taxi drivers. The Act incentivizes private enforcement by authorizing statutory damages of at least $10,000 in addition to court costs if a defendant is proven liable, and shields those who sue but lose from paying court costs. Plaintiffs are not required to have any personal connection to a provider in order to commence a lawsuit. The law contains exceptions in the case of medical emergency but not for rape or incest. On September 7, 2021, Governor Abbott asserted that the Act does not force raped women to carry pregnancies to term, because it gives them at least 6 weeks, and that the state would work tirelessly to make sure that we eliminate all rapists from the streets of Texas by aggressively going out and arresting them and prosecuting them and getting them off the streets. At midnight, immediately after the law went into effect, many clinics in Texas including Planned Parenthood stopped performing abortion procedures and stopped taking new appointments. However, many clinics reported an increase in patients at their clinics who had completed the 24-hour waiting period and sought to have the procedure done before the midnight deadline. The act is the first 6-week abortion ban to go into effect in the United States, even for a brief period of time. In Texas, an estimated 85% of abortions have been performed after the 6-week mark, which is often shortly after a pregnant woman misses her menstrual period, and before many women have confirmed or are aware of a pregnancy. The law is unique in that it is specifically designed to place the burden of enforcement on the populace through civil lawsuits rather than on state actors. This was engineered to deny abortion providers the opportunity to seek federal court injunctions against the enforcement of an unconstitutional statute.